We have Don Hulse today. Don is mining Vice President of Mining at Gustafson, and the title of the presentation is IG7 to SK 1300, past, present, and now what? So go ahead, Don. Thank you.
Thank you, Betty.
Yes.
Thank you for the invitation. Good afternoon, everybody. I will pretend I know what I'm talking about. I have been involved when Dr. Harry Parker retired. He asked me if I would be one of the co-chairmen of the Resource and Reserve Committee, and so I've been involved in this in the committee since 2014, and basically involved in the SK 1300 rollout since it happened. And so I will, I find it useful to try to find an applicable quote. And I think both of these have some, both of these apply to the situation. Basically, it's a whole new world with this in US minerals reporting. So I must say that please don't consider anything I say legal advice. It's my best effort, but we do not yet know how exactly the SEC is going to interpret this, or what it will, or what they will do with it. There have been, I believe to date, 1 or 2 reports filed and accepted that are posted on EDGAR. So I'm going to, to have a running start at this, I'm going to go back in history a bit. There was actually quite a nice framework laid out by Herbert Hoover in a book called The Principles of Mining in 1909. The framework has not changed appreciably since then, but there have been a series of different rules with the SEC. In 1939, they adopted Form S3 as one of the first countries in the world to formalize reporting. In 1981, that was turned into Form S18, which almost unchanged in 1992 became Industry Guide 7. In 2019, they published a new document, a new rule in CFR 17, section 229, which is known as the SK section. And as of the end of year of 2021, all US registrants, except those who are co-listed in Canada, will have to report using this format. I said that Hoover's initial attempt at this was pretty similar. He said you must determine the average metal content, the quantities of ore, prospective value, recovery, price, production cost, redemption of capital. So the roots of this pretty much still exist through the SME guide, the CRIRSCO codes, and this new rule. In a bigger scheme, modern history, we all know about BRIEX and what that did to the industry, but this started a little bit before that. In '94, the ICMM got involved, got a group together who in '97 published the Denver Accord. In 2002, CRIRSCO was formed, and then we had a bunch of countries, one by one, joining that methodology and accepting the CRIRSCO template as their, or some variation of it, as their reporting standard. In the US, we have a bunch of further dates. There were a number of updates. starting from 1981 up through 1987, and but all culminated in 2019 when the new guide was published. Actually, December of 2018. So what does this change? There's a few things. Industry Guide 7, as indicated below, was a little bony. Some elements were there, but there was not much flesh. They did have a reserve. They did have proven and probable reserves. SK 1300 has adopted the CRIRSCO methodology of reporting mineral resources, measured, indicated, and inferred, in decreasing geological confidence, and proved and probable mineral reserves in decreasing level of confidence. Mineral reserves have certain modifying factors associated with them to show that they are economic. They both have defined that there are 3 stages of projects, and your reporting depends on which stage, whether you are in exploration, development, or production. However, the new standard is still just a little bit bony, not quite as bad as before, but it doesn't really give you all of the details you need. So this, I think, is important. This is quoted from SK 1300. The proposed rules deviate in certain respects from the CRIRSCO standards. As explained below in a number of instances, we, being the SEC, have revised the proposed requirements in line with commenters' suggestions to be more consistent with CRIRSCO standards and improve the comparability of property disclosures. This should help decrease the expected compliance costs and the burden of the final rules. In other instances, we have not changed the proposed requirements because we believe that those requirements are necessary to protect investors. Overall, we believe the final rules reflect an appropriate consideration of the extent to which the final rules promote efficiency, competition, and capital formation. The final rules will modernize the Commission's property disclosure regime and hopefully place the U.S. mining registrants have placed the U.S. mining registrants at a competitive disadvantage, and by adding other requirements that will help investors make more informed decisions. So the CRIRSCO standard definitions were changed somewhat. I have read them several times. I'm not sure that there's a lot that's material in them, but you need to be careful. I will say this more than once. Please read the standard. Please read the rule. SK 1300 does not define a mineral or define public reports, but it includes the project stages. It includes the words economic viable. I duplicated highlighted exploration results, which is in CRIRSCO. Uses the words initial and final market study and investment and market assumptions, which translate into other things within CRIRSCO, but they are, all of it is sort of there, but there are some very specific things that have to be addressed when writing one of the SK 1300 reports. Now, this is very specifically defined under Canadian law, NI 43-101, you produce a technical report. Under SK 1300, you produce a technical report summary. And I believe that was always the intention of NI 43-101, but they have come to be fairly extensive reports. The meat behind the report and the sustenance of it has not really changed since many of us graduated from college, where a scoping study was 4 shelf inches a pre-feasibility study was 24 shelf inches, and a feasibility study was perhaps 4 shelf feet because of all the documentation that was required to achieve the scoping, pre-feasibility, or feasibility level of accuracy. The technical report summary is really intended to be a document. It is supposed to summarize that. And if you read carefully in the notes associated with SK 1300, they do not expect you to disclose all 30 volumes of the feasibility study, but if they request more information, they expect that you have done the studies which will inform the report, and that you can produce that information. For simplification, and this may be my simplification, but my vision of it is that there are basically 7 different tracks that have to be followed to put one of these reports together. You have to define the location, you have to describe the geology, you have to describe what was done for exploration, how the resource was estimated, how the mine was designed and the reserve estimate, how the mineral will be processed, and how that results in a feasible economic evaluation. And I have put together a flowchart highlighting how I believe all of those cross-link to each other. For anyone who really wants to see it, I can make this available to you after the talk. The sections, much like the standard definitions, are associated with, they're very similar. NI 43-101 has 27 sections. SK 1300 has 25. There's a section that's slightly different, reliance on other experts versus reliance on information provided by the registrant. There is more information in SK 1300 on market studies, or is expected to be, and a little more in NI 43-101 on deposit types and drilling. One thing that I'm aware of is that for information provided by the registrant, it is valuable for the preparer if they need information on, say, geohydrology or environment or other studies done that are not in their expertise, that those studies all be contracted directly by the registrant. If the registrant provides that information in good faith to the qualified person, and the qualified person is responsible for reading that, but if that is provided in good faith, the qualified person, I believe, cannot be held responsible for what was provided by the registrant. If the qualified person were to contract those services directly, he or she would assume full responsibility for anything that their subcontractors did because they are providing it to the registrant. So key factors that you need to take into account if you have only filed Industry Guide 7 reports. If it has progressed past exploration and there is a resource, you must describe the resource estimate. Key assumptions, qualified person's estimates for all commodities, estimates of cutoff grades, the qualified person's classification into inferred, indicated, and measured, and they must disclose the criteria that were used to classify it. Reports must be done by a qualified person. The SEC has defined a qualified person as an individual who is a mineral industry professional with 5 years of relevant experience and an eligible member or licensee in good standing of a recognized organization, which must be either A, an organization recognized within the industry, or 2, a board authorized by US, federal, state, or foreign statutes, such as a state professional engineer. We'll comment, historically, the SEC has referred to the SME Guide as a supplement to Industry Guide 7. It's expected that Appendix A of the SME Guide, which has a list of the recognized professional organizations, or RPOs, will be a reference for the SEC in determining point 2-1 of this. Also have information, the SME Guide and the RPO list have not ever been binding authority in the US. However, they have always been important resources for mining and minerals disclosure, and the reviewers for the SEC have consulted those historically. There is nothing about SK 1300 that changes how that happened in the past. So we assume that the SME Guide will continue to be a resource for them, and that following that methodology and those recommendations will be positive for disclosing your mineral resources. When you make mineral resource estimates, you must discuss the uncertainty. You have to disclose individual grades of each metal or mineral, and you must provide an opinion. You must physically state the opinion that technical and economic factors can be resolved with further work. The summary must comply with all disclosure standards for mineral resources, and resource estimates may be inclusive or exclusive of mineral reserves, as long as it is clearly stated with equal prominence as the rest of the item. It also requires, let's see. So finally, disclosing mineral resources aligns SK 1300 with CRIRSCO disclosures, and there's a definition of a mineral resource. Classification, many of you are familiar with this: inferred, indicated, and measured, in order of increasing confidence. And that confidence can come from several factors. It can be more persistent mineral bodies, more samples, or a history of successful resource development in the area that leads you to believe that this resource estimate is valid. The classification, there are no numerical standards or statistical standards. The classification is based on the judgment of the qualified person, as in other CRIRSCO standards. Modifying factors. Under Industry Guide 7, the modifying factor to make a reserve was a full feasibility study or an operating mine. Under SK 1300, it could be a feasibility study or a pre-feasibility study. But you have to describe the modifying factors, and these include environmental studies, permitting or defining the ability to permit the project, negotiations or agreements with local individuals and groups. And these all have to do with social and environmental. We are all very aware of the mining operating cost and capital cost factors and process operating and capital cost factors that have to be overcome to make a resource into a reserve. So this must address environmental studies, permitting requirements, closure planning. The qualified persons must opine on the adequacy of plans. You should state within the report that the plans are adequate and the registrants have developed their planning in such a way that it would allow this project to go forward. It's also worth mentioning if you will be handling toxic minerals or reagents and controls for those toxic materials, and in the case of certain countries, discussion of conflict minerals, and if that might apply to this deposit. I suggest that you refer to some notes in the SME guide talking about taking into account environmental, social, and health and safety impacts. Comments in the CRIRSCO template, which refer to the same as you are writing your reports. And the CRIRSCO template states that sustainability can refer to 3 principal themes. Since we know that minerals deposits are finite and will eventually be mined out, what does sustainability mean? Can this be mined and allow the environment to maintain itself with minimal impacts? Can the surrounding community continue its traditional economic and cultural activities? And is there an ability for newly created economic inputs to continue beyond the mine life? Can we set up local businesses? Can we help the people to develop themselves in such a way that their newly acquired standard of living from the mine might continue? Social issues and social license to operate are a measure of communication and transparency. And we, as authors of as qualified persons and authors of the reports, need to be able to describe that the registrants are taking the steps necessary to enable and facilitate this communication and to win the trust. As of this Monday, the SEC acting chair started to make the case for the SEC to develop a mandatory environmental, social, and governance reporting framework. Some of you may be aware that there are now funds and fund managers that actually cater to ESG criteria, as they call them. Having a strong outreach program and dealing with these 3 factors, environment, social, and governance, is a way to have access to additional capital assets that you may not have had access to as just a mining company. Some of the world's largest asset managers, and they met. This is from S&P Global. They mentioned several by name. BlackRock leaps out. Are emphasizing these products. A late 2020 report found that sustainably invested assets had grown at a higher rate than other assets. However, it's Washington, and the SEC is not likely to face an easy path to introducing a disclosure system, as quoted by 2 of the Republican members of the commission. So, what could possibly go wrong? There's a few things that are new, especially within the US. One of them is, please pay close attention to what you're reporting on. There are summary disclosures and individual disclosures depending upon the number of properties, whether each property is material to the company, and it's possible to do a short form where you report on a number of properties, especially after individual disclosures have been done the first time. Individual property disclosures, in the case of a new property or the first time it has been reported, they expect an individual property disclosure with a full technical report summary. Point 1. Point 2, market studies. Under the SEC, under SK 1300, the market studies are very well defined. For publicly traded minerals and metals, gold, silver, copper, lead, zinc, with active commodities markets, it's not so hard as it has not been. There is no recommendation or rule that the price is limited by 2-year or 3-year trailing averages. At one point, the SEC preferred that you use a maximum value of a 3-year trailing average. That is not currently true, but if you use other numbers, you must have done the study to be able to defend those numbers. There are both preliminary and final market studies, depending upon whether the project is at scoping level, pre-feas, or feasibility, whenever the mine's product cannot be traded on an exchange, unless there is an established market for the product or they have a sales contract. They mean, by saying you have a sales contract, means that that contract price is to be disclosed. Many industrial minerals are sold under private contract, and in many cases, the terms of the contract include confidentiality of the sales price. We have one client who is currently working with the SEC. It is possible to get a waiver that you can disclose that information. You can provide that information to the SEC, but not disclose it in the technical report summary. Although the qualified person would need to see that to determine that the mineral is valuable and is financially feasible. I don't believe this has been tested yet. We understand the possibility exists, we being the SME committee, but I don't think that anyone has ever tested this, and I have not heard of anyone receiving this kind of a waiver yet. I mentioned earlier, reliance on information provided by the registrant. The QP, if it comes from the registrant, the QP can rely on it. The QP should try to avoid contracting a third party and acquiring the liability for that information, and should work with the registrant to hire any other consultants. Last but far from least, under U.S. securities law, the qualified person is considered to be an expert. That includes something called expert liability. There's been a lot made of this in some of the early publications about SK 1300, is that it was a very dangerous report for a person to file as a QP. There are provisions in errors and emissions insurance, but the expert can be held personally liable if the qualified person is an employee of the registrant. He cannot be protected by that company's insurance, or I have been led to believe that, and they have pretty limited protection. But there is an option for a qualified person firm where only the firm signs for it, and the firm's insurance and legal protections do help to protect the individual QP. However, in practice, and this is from, I forgot to quote the source on this. This is from Dorsey and Whitney. They published a paper about expert liability. A purchaser may also sue any account engineer or other expert who has been named in the registration statement. However, notwithstanding the foregoing, a person generally will not be held liable if the person had reasonable grounds to believe that the statements were true and there was no material omission, the due diligence defense. And their last comment was, many qualified persons are already subject to these personal liabilities because they act for registrants that are Canadian companies. And so they have been personally identified in such registrants' SEC statements. I believe that under Canadian law, there is also a personal responsibility for the QP. So most of us have been doing this already, or many of us have been doing this already. And And I will say this again, be diligent, be careful, and be thorough. Most important, do not intentionally omit or falsify anything, which will make everything, which will fully expose the QP and the company. So how do we do this? My co-chairman of the committee, Brian Groff, has spoken with Ken Schuler, one of the mining engineers that works for the SEC. They have had a few reports come in and be sent back. And Brian asked, what is the most common problem? And the answer was, the qualified persons do not read the rule. Be careful, read the rule, understand it. The meat, as I would call it, of the rule, the part that is the rule itself, is only about 11 pages. There are an additional 5 pages of instructions. When it was published in the Federal Register, it was about 40 pages, but the rest is discussion and definitions. It's valuable, but really, you're only working with about 16 pages of actual material. Part 2, do not send a 43101. It is not the same. And step 3, as always, also true in Canada, when it says they need an opinion, they want the qualified person to state an opinion. This is adequate because. Lastly, don't panic. The studies are the same. We still do scoping studies. We still do pre-feasibility studies. The summary format that we must report in is new to us. We are still learning this, and the SEC is also still learning this. This was written with minimal input, minimal technical input, and lots of legal input. So there are some things that are not really technically precise, and how this happens will need to be worked out through the review and publication of the first generation of these reports. Remember, the public disclosure is more extensive than it ever has been. This is comparable to other jurisdictions, and Canadian mining companies had many of the same concerns when NI 43-101 was implemented. And within a few years, everyone was happy with the new format, and everyone moved forward. So it's a reaction to change. It'll be okay. Lastly, be careful, be ethical, and be very clear in your disclosure. That's errors made in good faith. I understand. I don't promise, but errors made in good faith will be tolerated and asked to be corrected. Errors made in poor faith will absolutely not be tolerated, as we all know. This from a presentation that the SEC did for the CRIRSCO board and the National Mining Association in the fall of 2019, including a website where you can get in touch with the SEC, the 3 mining engineers who work for the SEC, and they can answer questions. And as part of their presentation, they stated they will not answer hypothetical questions. They prefer to answer questions from registrants because they have the obligation to serve registrants. They do not have the obligation to serve consultants. But their mission is not to punish registrants or QPs. They want the disclosure to be clear and people to use the disclosure to invest wisely in whatever companies they choose. I hope very much this has been helpful to you. It's been an interesting ride. And thank you.
Well, thanks a lot, Don. That was really very interesting. I do have a comment from David Abbott. He says the registrant is responsible for determining that those they select as QPs must meet the definition. Therefore, registrants will look at Appendix A of the SME guide. And I think that I will ask you to send me a link to the SME guide, and I will send it out to all the participants.
I will. It is.
We can do that later and put it on the website as well.
We can do that later, and I can tell you that the SME website has an open section and a member section, and under the open section, there is a menu concerning reserves reporting that will get you to those documents.
Okay, great. But I'd still like to have a nice.
I will provide it.
So,
yep.
Thank you. We have also a question or a comment from Mark Bowron. So regarding liability, all individual QPs should at the very least operate under the protection of a limited liability type entity.
Very good comment, Mark. Thank you very much for making that. Yes, that should be, it is in their interest to do so.
Okay, that's really all the questions that we have, and we have some more time if anybody else has some other questions or comments. Just put them in the chat or the Q&A, either one. Don, do you have any other thoughts that have come up?
I don't. I will share one thing, which is that I have felt that some consultants in the industry have made a lot of the personal and professional liability in this case, and I have felt that they were using that as a sales tactic, and I find the ethics of that stretched, that you would try to scare people into using your services. It does not mean that you don't have to be careful when you do the work, but we work with big machinery, heavy rocks, and explosives. We all have to be careful when we do our work. So.
We do have another comment from Javier Ochoa. He says, it will be interesting to have a follow-up on this in a year's time once some real-world application has taken place.
It will be very interesting.
Yeah, so put us on your schedule for next year.
You're going to do this to me twice?
Yeah. Also, Mark Bowron says, is a Canadian company traded on a U.S. stock exchange required to file with the SEC?
Thank you. There are some rules about it, but cross-listed Canadian companies do get a bit of a pass on it, and they can file their 43-101 in Canada and refer to that. There is a description of how to do that within the rules, and I'm not sure that it's at all clear. If a registrant is in that position, I would recommend that they contact one of those numbers or the website for the SEC to confirm the details of exactly how that is done. It's possible, but I was not completely clear on the details.
All right.
And I believe that only works for Canada. I don't think that Australia or the LIM or any of the other exchanges have that ability.
Okay, we have a couple more coming in.
I saw Lee's question, which conflict of opinions between whom, Lee?
Yeah, how do you mesh reliance use of company provided information in an independent appraisal assessment, especially when ESG and environmental is addressed. This is equally important. What if there's a conflict of opinions? Good question.
Excellent question. I think we will know who was it made the comment? Danielle, I think we will know more in a year. What I have said, and Betty, you know, I have written on this, and some of you have seen my presentations to the SME on ESG and reporting, is that we don't know that it's going to go well, but I'm sorry, Lee, you're right.
Pat.
You are Pat.
Yes. Lee Pat. Pat.
I've only known you for what, 20 years?
Yeah, right.
The we have to, the existence of the conflict may be material regardless of who is right. That's correct. The historically social conflict was often defined by a blockade of the project. We would like to avoid that. To do that, the responsibility falls squarely on the company. The local community is already there, and we must reach out to them. We cannot guarantee that we will be successful, but the company, you should be able to see that the company has taken steps to reach out, to publish, to teach, to communicate about the project, and that not just get government permits, but to actually connect with the community. And in my opinion, it's good to consult the internet and local newspapers as to what is being said in the press about the project. Are there conflicts? Are there people actively opposing the project? And to discuss with the company, if they are aware of those, what has been done and what steps are being taken. I believe that if we as qualified persons can document what steps the company is taking and show that these are typically things that are done with successful projects, that we can believe that the project has a decent chance of moving forward. I know at least one consulting firm with an office here in Denver has specifically hired an ESG person to work on their technical reports. I don't know of any others that have done that yet. I had the fortune or misfortune of working on a project where I dealt with that on a daily basis. There's a lot written, and there's a lot of very academic material out there. There is some practical material about how to, and I can put in a plug that I and a co-author have written a section for the new SME underground mining handbook on ways to address this. I don't remember the publication date, if it's later this year or early in 2022.
We have a comment from David Abbott. The existence of the conflict may well be material regardless of who is, quote, right.
That's correct, Dave.
And I got a couple other questions. Mark Bowron asks, is there a public resource to search for the 1300s? I think that's the 1300 reports.
Please bug me until I get it to you, Betty.
Okay.
There is a way under Edgar, and I believe you search by the section number of the CFR for reports, paragraph 229.1300. But Edgar.com, much like CDAR.com in Canada, has the reports listed, and I will have to go back in my notes to find the exact search parameters that you put into to bring up those reports. But yes, they are available, not when they are filed, but after they have been accepted by the SEC, they are published on Edgar.
Okay, good. I think we have quite a few things to send to our participants after this is done. Javier Ochoa also asks, has there been any discussion with Canadian securities regulators regarding reciprocal application of SK 1300 with SEC grounded reports?
Craig?
Shall I unmute Craig so he can?
You should unmute Craig.
Okay, let me see. I can do that.
And Peter Christensen has just posted a comment of what he believes are the search parameters for reports.
Okay. Well, I'm not, sorry about that.
Hold on, we can do this.
Oh, you're the host. You can do it. You're the host. You're still the host.
Where is Craig? Allow to talk.
There.
There we go.
Hello.
Hi, Craig.
Hi, Craig.
Oh, hello. How do? So this is just my discussion, and as far as me as an individual, not as far as the commission. There's been no formal discussions with the SEC on reciprocal arrangements. There's a lot of similarities, and I think we will, as reports come in, use our judgment to whether or not there's things that don't work. But I think the plan we have now is that there will be enough similarities that we're not going to necessarily disqualify a report filed as a technical report summary under SK 1300. It should work for our purposes, but there are some differences that are critical with regards to like QP independence, which is required in Canada and not in with SK 1300. There's a few things like that that we will be watching for, but overall, it's going to be very similar.
Is it true, Craig, that for producing issuers that QP independence is not strictly required? I believe that was the case in the past.
That's still the case. So if the issuer or the registrant meets the definition of a producing issuer, then independence is not required. That's right. It's going to be more for the early stage reports, first time disclosure of a resource. Typically they are done by independent firms, but the company may decide that they'll do it internally. Those things we'll be watching for. So just a few things like that. There's not a lot of things, but a couple like that. But I think the overall will be as flexible as we can. So.
Okay, I think that I don't see any more questions. We will we'll get information out to everybody. This session has been recorded and it will go up on our website at some point. It does take a few days for that. We will get some more information to all the participants, and we
right. And
you coming.
And thank you very much, Pat, David, Craig, Javier, for all of your comments and questions.
And Mark Bowden.
Mark.
Yeah. Appreciate that. Okay. Thanks, everybody. Thank you for coming, and we'll be in touch.
Thank you.